Hello, everyone. Thank you so much for coming to our affirmative action teach-in. My name is Kevin. I go by he, his pronouns. I currently work as the graduate assistant here at the Asian American Cultural Center.
And hi, my name is Nana. I use she, her. I also work at the AACC, but in addition to that, I'm a political co-chair of the Asian American Students Alliance at Yale.
And we all thank you all for showing up today to our affirmative action teach-in. Today we have representatives from the NAACP Legal Defense Fund, Asian Americans Advancing Justice, and the Lawyers Committee for Civil Rights Under Law to come talk to us about race-conscious admissions, as well as the Supreme Court hearing on Harvard and University-Chapel Hill's affirmative action cases. Before we begin, I just want to take a moment to acknowledge the lands on which we are settled upon. We are coming from many places today, and we want to acknowledge the ancestral homelands and traditional territories of Indigenous peoples who have been here since time immemorial, and to recognize that we must continue to build our solidarity and kinship with Native peoples across the Americas and across the globe. Yale University and the Asian American Cultural Center, located in New Haven, Connecticut, acknowledges that Indigenous peoples and nations, including the Mohegan, Mashantucket Pequot, Eastern Pequot, Schaghticoke, Golden Hill Pagaset, Niantic, and the Quinnipiac and other Algonquin-speaking peoples have stewarded through generations the lands and waterways of what is now the state of Connecticut. We invite you to reflect on the relationship between Yale and these lands on which we sit, and consider one commitment you will make to support Native peoples. We also acknowledge that this country would not exist if it was not for the free and enslaved labor of Black people. We honor the legacy of the African diaspora and Black life, joy, and knowledge. So Nina will go over some quick Zoom etiquette for all those who are tuning in virtually.
Yeah. Hi, virtual folks. So you will notice you're on a Zoom webinar, so your mics are muted. And please just remain muted. You can feel free to use the chat to introduce yourself and where you're joining us from today, if you want to share pronouns or anything like that, and feel free to engage with one another in the chat throughout the event. But we'll just keep the conversation focused on the content that's being discussed in the teach-in as much as we can. And you can also use the Q&A feature of the webinar to ask any questions that you have specifically for our speakers, and we'll do our best to respond to as many of those as possible towards the second half of the teach-in.
Okay. And then without further ado, I'm going to turn it over to our speakers who will be leading today's teach-in.
Hi, everyone. I can start us off. My name is Allison Sharfstein. I am a legal fellow at the NAACP Legal Defense Fund. I work on education equity and racial justice issues at LDF. I was a teacher for many years before I went back to law school. And before that, I was also a Yale undergrad. I was JE 2012. So really wonderful to be with all of you tonight. And I will pass it over to my colleague, Rita Wang, to introduce next, and then can pass it along down the line.
I had to unmute myself. Hi, everyone. My name is Rita Wang. I use she and they pronouns. I'm actually a 2019 Yale graduate. I was in Morse College. I was also a really active member of the AACC. I was a peer liaison. I was also a lead organizer for the Coalition for Ethnic Studies, and just really excited to be here and help connect LDF with Yale. I actually was able to, what led me to LDF was after the DOJ sued Yale in 2020, LDF reached out to us and we started talking about potentially representing students. So really happy to be here and continue working on that relationship. And I'm going to pass it on to my line buddy, Taylor.
Hi, everybody. So great to meet you all. My voice is a little raspy right now. My name is Taylor Dumpson. I currently serve as Associate Counsel at the Lawyers Committee for Civil Rights Under Law. Before coming to the Lawyers Committee, I was an intern at the Lawyers Committee. I was a client at the Lawyers Committee. And I went straight to law school sort of after all of those different things. And so I graduated from Cardozo School of Law, which is a predominantly Jewish law school in Manhattan back in 2021. And I now work at the Lawyers Committee full time. And it's a really, really great opportunity to be here. And when I wanted to say thank you to Kevin for that wonderful land acknowledgement and for grounding us in that history. I really, really appreciate it, particularly because I'm also Algonquin. I am Narragansett descent, and I'm also descendant of enslaved people. So I was really, really appreciative of that. And I'm going to pass it over to Nia.
I have not mastered the art of Zoom, but hi all, my name is Niyati Shah. My pronouns are she, hers. I am the Director of Litigation at Asian Americans Advancing Justice, AAJC. And along with LDF and Lawyers Committee, we represent ASA among other organizations in Yale as if that case were to proceed. And we also represented the student Amici Plus in Harvard and submitted some briefs, amicus briefs in these two cases on behalf of Asian Americans. And so it's really good to be with you all. And thank you, Taylor, for sharing. And thank you for Kevin for that wonderful introduction.
Sounds good. So I will be kicking off the rest of this little shindig we're doing, this little teach-in. And I think I forgot to tell you all what I actually do at the Lawyers Committee. Forgive me because I've had a little bit of sleep over the past couple of days. As you know, oral argument was today in the affirmative action cases. So beginning at about 1 a.m. this morning, a little before that, maybe I guess 12 o'clock this morning, Rita texted me and told me that the line was already gathering in front of the Supreme Court. So I have literally been going nonstop since then. So it's so great to be with you all. And Kevin, if you don't mind, please click the slide. So I work at the Lawyers Committee, and I particularly work in the Educational Opportunities Project. And I also work in the James Byrd Jr. Center to Stop Hate, where I work on hate crimes work. And so the intersection of my work is always racial justice. But particularly for this teach-in, I'm here to talk about affirmative action. I worked on both of the Harvard and the UNC cases at the Lawyers Committee, and I helped to write one of the merits briefs in the UNC case. So the real question is, what is affirmative action? There's a lot of things we hear all the time, but we don't actually get a clear definition. So affirmative action basically refers to a set of policies initiated originally in the employment context and in the education context to address disparities caused by racial discrimination through using race-conscious means. So what it really means is looking at how people have been discriminated against and been treated unfairly and being able to take affirmative steps to be able to solve some of those problems. Next slide. So when we think about affirmative action, I think a lot of people tend to think of the pictures at the bottom, but I want us to remember that affirmative action didn't just happen overnight, and we didn't just get here overnight. So I'm going to give you a little bit of some background behind this. So the challenges that we're seeing right now against affirmative action, the challenges we're seeing against culturally inclusive education, whether that's these Don't Say Gay bills, or whether they're attacks on critical race theory or inclusive education in other ways, we've been seeing this kind of pushback against integrated education for years. We've seen this going back to the 1960s when people were protesting busing and were protesting integration. And we've seen that now. And we're also seeing that, like I mentioned, with the attacks on inclusive education in the 21st century. So these are just a couple of the pictures that I wanted to just sort of ground us in so that we know where we've been and where we're going. Next slide. Thank you. So what does race-conscious admissions mean? And basically what race-conscious admissions is race-conscious admissions are a form of affirmative action policy. So like I said, affirmative action is really taking affirmative steps to try and do something to remedy this big problem that we've got. And so affirmative action policies, our race-conscious admissions policies, are a type of affirmative action policies that allow universities to really ensure that all students, no matter what their backgrounds are, have equal access to higher education. And they do this through using what's called a holistic admissions plan. So most universities look at a variety of factors. In the UNC cases and in the Harvard cases, universities looked at almost up to 40 different factors, ranging from where you live, what your ability is, what sports you do, what your hobbies are, what kind of things you're into. And so all of those different things are what we think of as diversity, whatever kinds of diversity that is. And so that's what we're trying to foster through race-conscious admissions. So when a university makes its admissions decisions underneath of these holistic plans, it really goes back to like two main Supreme Court cases. And that's Regents of University of California versus Bakke, which was a 1978 decision where a white applicant was trying to get into University of California Medical School, and he was denied. And so he challenged the case, and basically the Supreme Court came back and said, well, race in this situation was just considered as one of many factors, and as long as quotas aren't employed, then that's okay. about 20 some odd years later, 20 some, 30 some, I can't do math right now because my brain's a little fried. Grutter came out, right? And so Gratz and Grutter are both 2003 decisions. They were decided on the same day, but sort of had different outcomes. And so what Grutter tells us, or Grutter tells us, is that the use of race is a compelling interest for universities to obtain the educational benefits that flow from having a diverse student body. So those factors of diversity that I was talking about earlier, like what kind of things do you do? What languages do you speak? Where are you from? What are your hobbies? Those are all kinds of things that make us different from one another, that also allow us to build solidarity with one another. And so that is really at the crux of inclusive and holistic admissions. So the crux and like center of race conscious admissions plans. But it also is still required because in this situation it's using race or it's taking race into consideration. It's still subject to strict scrutiny, as the Supreme Court has made clear through its precedent. So that means that it has to have both a compelling interest and it must be narrowly tailored towards achieving that interest, which basically just means that you have to have a really, really important thing, like an important concept, and you have to be very, very specific about how you intend to achieve that. And it can't be sort of vague or broad, things like that. That's what the narrowly tailoring aspect is. Next slide, please. So how did we get there? I just want to sort of go back to the historical context. We have seen attacks on education, and particularly inclusive education. And when I say inclusive education, I specifically mean in education that tries to bring in people from all backgrounds. This goes back to the 1740s, when we saw anti-literacy bills being passed across southern states after slave rebellions, where enslaved Africans were learning how to read and were demanding liberty in the South. And southern states were like, we can't have that. That's not a thing we allow down here. So what folks started to do was they started to pass these laws and say it's against the law to educate Black folks. Well, we saw that continue with Plessy versus Ferguson. We see that with Dred Scott. We see that with all those big cases that are distinguishing people of color from white people, people of color from citizens, people of color from what it means to be American. Then taking this to Brown versus Board of Education, where the Supreme Court overturned the longstanding separate but equal doctrine. That happened when my grandmother was a little kid. My grandmother and my grandfather never went to integrated schools, never sat in a classroom with a white person. And my state of Maryland, folks don't think about that a lot, state of Maryland was one of those states that was asked in the first Brown versus Board of Education to come back and defend its policy, to go back and say why you support segregated schools. And so this is something that is particularly important to me. And so we have seen this movement, affirmative action policies, pushing for inclusive education, and all of those kinds of things really be geared by students, student leaders, civil rights leaders, advocates, have really taken the mantle and taken it and run with it. And so what that really means is holding the government and holding states and schools accountable for their promises and making real the promises of integration to ensure that every student has access to a range of opportunities and that none of those are disclosed to them, or the doors are not closed to them because of their race or their ethnicities or their backgrounds or their nationality or the languages that they speak. And so today's battle to really defend and affirm affirmative action policies and race conscious admissions, it's all about making sure that everybody feels seen, everybody feels valued, and everybody is able to be heard in an admissions application. Next slide, please. Thank you. So where did affirmative action come from? So I talked to you about the history. So now you got it. You got a little historical background, 1700s to now. We've seen the little arc. But affirmative action really comes to us through two major executive orders. The first executive order is in 1961, and it's by JFK. And he basically says that we need to take additional affirmative steps to realize more fully the nation's policy of non-discrimination. And so he recognized in the 1960s that folks were not doing what was now asked or demanded of them by the Supreme Court out of Brown versus Board of Education, was to make sure that everybody had access to these kinds of spaces. And because folks were not making true on those promises, and they were not doing it with all deliberate speed, John F. Kennedy and other folks made it a point to be like, we're going to hold you accountable. We're going to come up with something to sort of step in that space. And so the first executive order on affirmative action is particularly related to the employment context, and it is focusing on making sure that every contractor has the ability to achieve a job and to thrive in their job without regard to their race, creed, color, or national origin. And so I think all of those are really, really important, and those identity groups have expanded with the executive order that was passed in 1965 with Lyndon B. Johnson. This was amended most recently, or one of the most recent amendments was in 2014, where gender identity, sex, and sexual orientation were explicitly added to those classes of race, creed, and color. And so in that executive order on affirmative action in 1965, it was still about contracting, but it sort of started to get at non-compliance. So this is actually where the enforcement mechanism comes in for doing affirmative action, which is that in the event that a contractor is non-compliant, it almost canceled, terminated, suspended, or completely interfere with their ability to pursue other federal government contracts. And so the plan was that the government would be able to help enforce these affirmative steps that everybody should be taking because it wasn't happening. Next slide, please. And so when I think of affirmative action, and you all think of affirmative action, I want you all to sort of think about this picture right here. And this is a picture of Mr. McLaurin. And Mr. McLaurin is a student at the University of Oklahoma. He was trying to go to law school. And he is, as you see, he's actually being taught in a classroom, in a closet, adjoining the classroom, where all of his classmates, or all the white classmates, are sitting in the main room. And they can see the screen, they can see the teacher, they can ask questions, they can raise their hand, they can interact meaningfully. And he's literally cast to the side, made to feel invisible, made to be not seen, not able to engage in that space. And so this predates the affirmative action the executive orders, the one from Kennedy and Lyndon B. Johnson, because this case was in 1950. But this is actually one of the cases that was cited in Brown versus Board of Education that really helped get us on that track towards making these kinds of affirmative steps. And so affirmative action was needed then, and it is still needed now to ensure that people of all backgrounds, people of color especially, receive meaningful access and equal opportunity. And that equal opportunity part is really important to me. There's a quote that I think really exemplifies this meaning of what does it mean to have affirmative action and why. And it's by LBJ. And he said, "We seek not just freedom, but opportunity, not just legal equity, but human ability, not just equality as a right and a theory, but equality as a fact and as a result." And that's something that I genuinely believe. And I think that a lot of us, those in this room, you know, the virtual room, those in the actual classrooms right now, wherever you all are tuning in from, I think that a lot of you all can resonate with that as well. Next slide. Please. So basically, what was at stake today in the SFFA versus Harvard and SFFA versus UNC cases? Basically 40 years of precedent going all the way back to the Bakke decision I talked to you about that was in 1978 that allowed race-conscious admissions and allowed universities to consider race within a very specific sort of framework and test. That whole precedent stands to potentially be overruled. And what that means is that students like me, when I was a student, I wrote about my experiences with race in my application to college. I most certainly did when I got to law school. I wrote an entire diversity poem about being a Black woman pursuing a legal education and thinking about, well, in the legal profession and in, you know, most of my law or pre-law classes, I didn't learn about people that looked like me in the words of philosophers. We weren't learning about Black women, critical thinkers. We weren't learning about people and seeing that representation. And so for students that their race shapes their experiences as a very, very critical part of who they are and how they show up in the world, that is at stake because in these cases, what SFFA, Students for Fair Admissions, is trying to get the Supreme Court to do is they're trying to get them to completely disallow any ability to consider race in your application. So what that means is out of 40 different factors, like where you live, how much money your family makes, where you go to school, and all these things, the one thing you can't talk about is your culture, your ethnicity, or your race. Because in a world where race-conscious admissions are required to be blind admissions, and you're not able to see that whole bigger picture, you'd be able to talk about the sports you play, you'd be able to talk about the hobbies you have, the things you do for fun, but you wouldn't be able to meaningfully connect those to your lived experiences. So I wouldn't be able to talk about Kwanzaa. I wouldn't be able to talk about my family's indigenous roots. I wouldn't be able to talk about anything because that would squarely implicate my race and my identity in a way that now SFFA is petitioning the Supreme Court to say is unconstitutional. But we know that's just absolutely not true. Why do we know that? Because Ketanji Brown Jackson, or Justice Ketanji Brown Jackson, gave us a really good educational lesson a couple of weeks ago. And we saw some of that play out today in the oral arguments when folks were asking about the originalist intent behind the 14th Amendment. And that sounds like a lot of legal jargon and legalese, but it's really, really not. The 13th, 14th, and 15th Amendments, as I'm sure a lot of you all know, were passed during a time and during Reconstruction. Those are the Reconstruction Amendments. Those amendments gave Black people the rights to vote, the rights to be considered citizens, gave the rights of non-white people to be citizens. The ability to be born in the country and then become a citizen is really a right that so many of us benefit from, but was initially found, or that right grew out of, as you mentioned, Kevin, in the beginning, it grew out of that struggle for equal access and rights for newly enslaved or newly freed people or formerly enslaved folks. And so those kinds of things are all really, really tied together. And so the 14th Amendment at its core was passed with race consciousness in mind. Even the proponents, the people who introduced the 14th Amendment into that Senate and into that House were basically like, cool, but we got to do something about these people we've now decided are free. They're free, but can they vote? They're free, but can they engage meaningfully in society? They're free, but can they actually thrive in this new reality? And so that's where a lot of this sort of came from. And so this idea that the 14th Amendment's Equal Protection Clause requires you to not even consider race to be able to solve race-based problems is laughable, right? It's absolutely laughable, because that sounds really similar to people saying the best way to get rid of racism is to stop talking about racism. And that just doesn't stop the reality of what we know, which is that we still experience it regardless of if we talk about it or not. And if we turn a blind eye or if we look the other way, it is not, doesn't mean it goes away. It means that it still impacts us. We're just not talking about it. So that's a lot of what's really, really at stake here. And what that means, and I want you all to think about what that means across all the colleges and all the universities, HBCUs, historically Black colleges and universities, historically and like growing HSIs, Hispanic serving institutions, and tribal colleges. All of those institutions, every single last one of them, considers diversity in a meaningful way. So it's not as if HBCUs are not diverse, because we know that racial groups and communities are not a monolith. I can be Black from America and not have the same lived experiences as somebody who is Black from Ghana and somebody that's Black from the Caribbean. So that's the same thing as saying, you know, it's like saying all Asians do the same thing or all Asians are exactly the same. That's not true. That's just not the reality. Because being an Asian American born in the United States doesn't mean the same thing as being an Asian American born in China, or an Asian American born in Thailand, or an Asian American born in Vietnam. All of those experiences are so different. The cultures are so rich and so valuable. How would you talk about yourself if you couldn't talk about who you are? I don't know how I would even introduce myself. Like, I introduced you all today. Like, I introduced myself to you all as a descendant of enslaved people and indigenous people. But that's how I show up in the world. And so I don't know how I would be able to do any of that. And so that's really what's at stake right now in these cases. And I got to hear some of the oral arguments today. I listened outside of the Supreme Court while we were waiting in line to the UNC oral argument on my phone with my mom and with Rita and a couple other folks out there. And then we actually got to go into the courtroom for the Harvard oral argument and being able to see the justices ask the questions and to see sort of how those things played out in the real world. So that's that on that. And feel free to let me know if you have any questions about anything that I just shared. I think that's my last slide on the deck. So I'm going to pass it over to whoever's next.
Thank you, Taylor. That was an incredible background and overview, and I'm just feeling so inspired, and I really can't believe you did that all on so little sleep. I am, so honored to have you as a colleague in this work, given that that's what you do on 2 hours of sleep. I can't wait to keep working with you when you're well rested. So I'm going to just give a bit of an overview of sort of this latest challenge to affirmative action and kind of build out what Taylor was talking about historically, and so we can understand really where this, modern attack on affirmative action is coming from, and how it is intentionally developed to divide communities and to pit us against one another rather than to be in coalition and solidarity. So the 3 cases that SFFA, which is Students for Fair Admissions, have brought recently are the Harvard and UNC cases, which you've heard about already today. But there's also a pending case by SFFA against Yale. And so that's another, obviously, something I know you all want to know more about, and we want to share with you more about so you can understand how this impacts you and your university. Students for Fair Admissions is an organization founded by Ed Bloom, and we'll talk a bit more about that. So next slide, please. As Taylor said, there is 40 years of precedent in Supreme Court cases upholding race-conscious admissions. And it's not always that usual to have so many Supreme Court cases saying similar things, because usually once a case is settled law, that's the law, it's settled. But the groups against affirmative action have been really persistent and have continuously gone back to the court, trying to get a new decision, essentially on the same idea, which is this limited consideration of race among many other factors in putting together a diverse group of students who can learn from one another, who can better one another, and who deserve access to higher education. So as Taylor explained, the first case sort of laying out race as a permissible factor among many others in university admissions is Bakke. And then there's a series of cases after that. So we've talked about Gratz and Grutter, and then just a couple of years ago, 2013 and 2016, there were 2 cases out of Texas, Fisher 1 and Fisher 2, again, attempting to take down the use of race. And again, the Supreme Court upheld it. And so that is why, there's so much at stake in the court hearing it again, because, the opponents of affirmative action are seeking a new result. So next slide, please. So I want to talk about Ed Bloom and SFFA and how the strategy of attacking affirmative action has shifted. So in the 4 cases that I just mentioned, as you can see here, there were white plaintiffs challenging affirmative action. So these were white folks who said, in order to bring a court case, you need to have a harm, you need to show an injury. And these were folks who said, I was not admitted to the university I wanted to attend, and it's because of my race. It's because of the fact that the university considered race and used that as a negative against me. There's a lot wrong with that approach, and the Supreme Court, as we've been talking about, each time said, no, actually, the fact that you were not admitted may have had absolutely nothing to do about your race. You may have been less qualified. You may not have brought the perspective or the particular needs to the university that they were looking for. These are competitive programs, and it was not your race that contributed to your admissions decision. And the university is allowed to continue considering race in a limited way as it makes its admissions decisions. And so after Fisher, which you saw was quite recently in 2013 and 2016, Ed Bloom changed his approach. And I think it's important to hear from him directly, which you will, and you can go to the next slide, about why he shifted and sort of what his intentions were here. I'm not hearing it, but if you all are, that's good. Can you all hear it? Yeah, okay.
Allison, I can't hear it. Did you check the box?
Kevin, you need to unmute.
Oh, I needed to be on mute.
No, Kevin needs to unmute as the host.
Yeah.
Got it. All right, let's try one more time. It's just a couple of seconds long. And if it doesn't work this time, I'll paraphrase what he said. But let's see if this will work.
Yeah, it worked on our down here, but
Okay.
Of these lawsuits is to eliminate the consideration of this. So I needed plaintiffs. I needed Asian plaintiffs, and finding plaintiffs to challenge the Ivy League admissions policies, Harvard in particular, is not an easy thing to do. So I started. I designed 3 websites: harvardnotfair.org, UNC, University of North Carolina, notfair.org, and uw.fair.org, University of Wisconsin.
So apologies to those of you who had to hear that twice, because it's somewhat upsetting, I think, to listen to. But this is, and it's fine, you can keep the slide where it is. This was the pivot that Students for Fair Admissions made. They saw that they had lost these cases by bringing white plaintiffs, and so they sought out Asian plaintiffs, and they did so with not respecting, as Taylor talked about and will continue to talk about, the wealth of diversity and difference of experience for Asian Americans seeking admission to college. And so that is the sort of organizing force behind these latest challenges to affirmative action. And important to keep in mind as we talk about sort of their goals and how the outcome in this case will impact everyone as they seek to attend higher education institutions. So I wanted to give a brief overview of the case at SFA against Yale, and then we'll talk more about how affirmative action impacts Asian American students more generally. So there are a couple of points here. You can kind of click them through, and it'll give us a bit of a timeline. So as Rita mentioned earlier, in October of 2020, the Department of Justice sued Yale using very similar claims that we've been talking about in these other cases, alleging that Yale's limited consideration of race in admitting students and compiling its classes violated the Equal Protection Clause of the 14th Amendment. And as Taylor already alluded to, this argument is suspect because the 14th Amendment was passed to provide rights to newly freed people and was meant to expand access to civil rights. But nevertheless, the Department of Justice in that case used the same arguments that SFFA had made in its cases to allege that Yale's consideration of race violated that amendment of the Constitution. It's important to note that DOJ, that this is when the Trump administration was in power. So this was a lawsuit brought by Trump's Department of Justice. And SFFA a few weeks later requested to intervene and participate in the case. And the court rejected SFFA's request. They felt that the Department of Justice was adequately bringing this claim. And then in February of 2021, the Department of Justice dismissed the suit. And you'll notice that is soon after President Biden was inaugurated. So this happens when often in many situations with a change in administration, they will often take different positions. But in this case, it resulted in the withdrawal of the DOJ suit against Yale. And I think there should be a couple more events on this timeline. So unfortunately, after the DOJ dismissed it, sort of withdrew its lawsuit, SFFA again sued Yale, and they had their sort of papers ready to go because they'd already requested to participate in the case, and so they again sued with the same claims that the limited consideration of race violates the Equal Protection Clause. There's one more piece here. So in May of 2021, the court granted Yale's request to pause the case. So Yale said, look, we believe our current admissions policy is constitutional under the court's precedent in Grutter and Gratz and Fisher. And unless that changes, you know, we want to defend our policy as it is, but because the Supreme Court is, you know, maybe considering it at this point, the Supreme Court had not agreed to hear the Harvard and UNC cases, but there was anticipation that it might. They asked for a pause in the case, and then, as you know, the Supreme Court did agree to hear the cases. They heard them today, and so what the Supreme Court decides in this case will, of course, impact this pending suit, again, pending but paused suit by SFFA against Yale. So, you know, that's why one of the many reasons we want to sort of keep you abreast and connect with you all about your experiences at Yale. Next slide.
Hey guys, so a little bit more about how Ed Bloom treats Asians and how he has treated them and how he's going forward with us. Obviously in Harvard, there was no distinguishing. He treated us as a monolith. We are not, nor are we a model minority. And we understand when you look at disaggregated data that levels of educational attainment for AAPIs differ between ethnic groups. Many Pacific Islander groups and certain Asian groups, including Southeast Asians like Vietnamese, Cambodian, Laotian, and Hmong Americans, have lower educational attainment levels than the national average and are very similar to our African American and Latino or Latinx brothers and sisters. And on the other side, there are some Asian groups that have high proportion of employment-based immigrants, such as Indian Americans and Chinese Americans, who have higher levels of educational attainment among all Americans. And in Harvard, the percentage of Asian Americans in Harvard's admitted class has grown under affirmative action policy since 2010 by 27%. And Asian Americans comprise of nearly 28% of that 2026 class, most recent. Moreover, studies show that if we eliminated race-conscious admissions, in 2016, a study found that that would reduce, if we eliminated Asian Americans and Latinos or Latinx applicants from Harvard's application pool, it barely increases Asian American admissions, maybe by 1%, but it would also make it quite unlikely that rejected Asian American applicants would be admitted even under a system that does not consider race. So there's no remedy here that will achieve any benefit to Asian Americans by eliminating race-conscious admissions, which is very important to keep in mind. And when it came to Yale, Ed Bloom decided that, you know what, these policies only discriminate against these other Asians that I like more. The, you know, so-called non-Southeast Asians, Southeast Asians are you know, that they don't count, you know, there's no discrimination against that. And, you know, that is highly problematic. And we can go to the next slide. And so the other point in all of this, of course, is that, you know, we know that 2/3 of Asian Americans favor affirmative action because, as we explained, that it is beneficial to us, that ending race-conscious admissions doesn't change the outcome for us. And as we've explained through student testimony and other evidence, that it in fact helps the underrepresented Asian Americans and underserved Asian American communities, particularly the Southeast Asian American communities. And, you know, more and more studies are coming out, including recently Georgetown Center on Education and Workforce, that admission policies, they were just test-based scores, these so-called race-neutral metrics. About 20% of Asian Americans attending elite colleges wouldn't be admitted still. And, you know, we know that with race-conscious policies, Asian American representation in colleges and universities has risen from 3% in the class of 1980 to 25%. Or 26% at Harvard College. So, you know, I think there's some skepticism here that comes with what is the point of ending race-conscious admissions, because it doesn't seem to really help Asian Americans, and who does it really help? And so let me turn over to the next speaker.
Yeah, so before we get to talking about oral argument today, we just wanted to quickly touch base on some of the harms about that will inevitably result from eliminating if race-conscious admissions were to be eliminated. So this slide is what Niyati was just another point Niyati was just making about how changing admissions not to consider race would not actually have a benefit on Asian American students. About 20% of Asian Americans attending elite colleges would not be admitted if admissions were based strictly on test scores. Next slide. This would greatly impact, as Taylor touched on at the beginning, the ability of students to present themselves and discuss their identities when they're applying to college. So this is a quote that comes from one of LDF's clients in the who are amici plus in the Harvard case. Emily said, if students cannot even discuss their home reservation, since that would likely identify their race, how can they possibly expect to give the Harvard admissions office a reasonably full picture of who they are in their admissions essays? And I have to say, as Taylor was talking, it was making me think back to what I wrote, one of the things I wrote in my Yale admissions essay. And I wrote partially about my Jewish identity and about a prayer that we say during the Passover Seder, which is a celebration of the biblical story of the Jews being freed from Egypt. And it says, in every generation, every Jewish person needs to remember themselves as if they were also slaves in Egypt. And the teachings around that is that it's really important, given a Jewish identity in this prior history of oppression, that we see ourselves in those who continue to be oppressed and work towards justice. And that had a huge effect on me and the things I'm passionate about. And I was able to share that in my admissions essay. And I believe it helped to, to convey who I am as a person. But the fact that that would be acceptable and so many and pieces of someone's racial identity would not be is extremely unfair. And actually, Justice Brown Jackson had a line of questioning in the oral argument today that kind of got to this point, right? That prohibiting students from discussing their racial identities actually provides a plus or a benefit to those students who have other identities that they can discuss and that may be desirable to schools. And I just think, I wanted to share that because Taylor's description of how she presented herself made me think about how sort of incredibly inequitable it would be if students are unable to discuss this part of their identity under a non-race conscious process. Next slide. Another major impact, and we've touched on this a bit, is that if race-conscious admissions were to be eliminated, there would be hundreds of Black and Latinx students who would not be admitted. So in the Harvard case, the research, the statistical analysis showed that 220 students would have disappeared from Harvard's freshman class if SFFA prevails in requiring a race, not eliminating the consideration of race. And most of those students would be replaced by white students, not by Asian Americans. And so you can start to see kind of who this, the elimination of consideration of race would really benefit. Next slide.
And so this is actually one of the quotes that came from our amici. So amicis are sort of like friends of the court. It's really what it means. And so one of our amicus briefs that we had submitted in the UNC case was by the American Educational Research Association, AERA, and they basically talked about the harms associated with isolation and tokenization. So I know when I was in college, I don't think I was ever in a class besides my African-American experience in performing arts class that I was not one of only 4 Black people in, right? And so being at a predominantly white college, a predominantly white institution, I went to American University. It was about 7% African-American, and I'm actually a hate crime survivor, which is sort of how I do hate crimes work with the Lawyers Committee. And so this particular quote really, really resonates with me and my own lived experiences, which is that when the percentages of Black people and Latinx people are too low, it actually causes an increased risk of hate crimes because of their token status. And so what that means, and what we talk about a lot of times in the hate crime context, is that if there are not enough of you to literally blend in amongst your community, it makes it really, really easy for people to point to you and say, you know what, you I'm going to target you for something. I'm going to make you a target. I'm going to make you a victim. I'm going to discriminate and harass you. And unfortunately, on college campuses, you all know just as much as I do, bias motivated incidences happen every single semester at almost every single college. And sometimes they're addressed by the university, sometimes they're not. Sometimes they're microaggressions you hear in the dorm room, and other times they're more explicit acts of like violence. And so when we think about what does isolation and tokenization and these harms, I know Justice Thomas today said something along the lines of, parents send their kids to school because they want them to learn about science and, chemistry. They don't need to go to school to feel good, right? But you can't learn in an environment if you feel unsafe. Safety is one of those basic things on like the hierarchy of needs. Like you have to be able to feel safe to be able to do anything else. And if you are living in an environment, because a lot of students live on campus, you're living in an environment that is literally hostile to you and your identity, how can you thrive? I mean, and I'm just asking that as like a rhetorical question. How do you thrive in a space? I mean, everybody thrives in spaces because they dig deep and find resilience, but thinking about all the ways in which your own college experiences would be very, very different if you had the ability to be at schools where you're not having to demand that your university do something to fix their own problems. If I was a college student at AU and I wasn't having to fix racism on campus, I feel like there might have been some other things I could have learned while I was there, except I was being a student leader, much like Rita was. I was being a student organizer. I was one of those little rebel rousers. I saw office at campus life all the time. And that really shaped my experience when I was on campus. But I think all the time about the stress that puts on Black and Brown and just Indigenous folks. And it's really, really difficult sometimes because your parents want you to go to school both to have a good time, but also to get an education. My dad always said, I send you to school to have an education. I didn't send you to school to make friends. I didn't send you to school to do X, Y, Z. And so that was always in my house. That was always the reminder for me. But it became very difficult for me to be able to go to school and enjoy my education and to learn something and to benefit from it if I wasn't feeling safe, if I wasn't feeling seen, if I was just feeling like I had a target on my back every single moment I walked around campus. Next slide.
Before we turn it over, can we go back to that one? We can end on this slide, and I was not in the court, but my colleagues were, and I'm really excited to hear from them and for them to share with you their impressions, but just wanted to share this incredible photo, which I was able to snap outside the court this morning of your classmates. This was the Yale delegation that traveled to DC that celebrated diversity with us on Sunday at a really incredible event where we heard from civil rights leaders, we heard from current students at Yale, Harvard, and other colleges. We heard from the children of the first people to integrate UNC when it was an all-white institution. So it was just, that was an amazing event on Sunday. And then of course today, again, people showed up through the rain outside of the court to rally in support of affirmative action and in solidarity. And so you hopefully will recognize some of your classmates here in this photo, and I will turn it over to my colleagues to share their impressions from the oral argument today. Niatia, if you want to start.
Yes, hi. So I was lucky enough to be in there. I didn't get up at 1 like Taylor did, but I was there in line at 5 a.m. this morning. It was on the Supreme Court bar line, and we got to go in. And I'm going to step back and just tell you guys, you may already know this, so apologies if it's things you already know, but the way the oral arguments went was UNC's case went first, SSFA argued, then UNC argued, and then our student intervener argued after that, and the United States government argued, and all of these people, UNC, the student interveners in the UNC case, as well as the United States government, all argued in favor of race-conscious admissions. And I see a question in the chat, and yes, oral arguments or the audio is available for you to listen. It was a marathon argument with both cases, about 5 hours long. So when Taylor and Rita and Allison are talking about, we're a little fried. Our brains really are a little fried right now, but bear with us. So in the course of those arguments, I want to step back and just raise a couple of interesting points that made. And then after those UNC arguments, there was about a 10-minute break where there was a mad rush to the bathroom because folks had been out in line for hours and hadn't had a chance to use the facilities. And then we got back in, and it was Harvard's turn, where Harvard presented again, SSFA presented their case against Harvard. Harvard made their arguments, and the United States made their arguments. So that was the structure of what happened in the courtroom. It was a packed house. So a few points that I'd like to make. One of the things that, was made towards the end of the UNC argument by Justice Ketanji Brown Jackson, who was not, who recused herself from Harvard as a member of their thing, was a question about what we really value, right? Like, what are we giving value to? And she used an example of two students who were otherwise on equal par with each other in terms of their academics and extracurriculars and so forth and so on, who wanted to apply to UNC. And one student said, my family has been in North Carolina for 5 generations, and every generation I've had an ancestor who's entered and attended UNC, and I would like to. And you have a Black student who says, my family has been in North Carolina, who's a Black student for 5 generations, and none of them have ever had an opportunity to access higher education, and I would like to attend UNC. And under SSFA's argument, who will get the preferential treatment? Will it be that white student, or would it be the Black student? And the answer was very clear. And the question was, why are we valuing the white students' experiences over the Black students? Because of course, race is not going to be considered. You cannot get a tip for that anymore under SSFA's worldview and what they are asking this court to do by overturning Grutter and Gratz. Right. So hopefully that also answered one of the questions that was in the chat about what would be considered if you were to talk about race. And I think that was a very illustrative example that Justice Ketanji Brown Jackson used. And I would say that it was echoed throughout the argument that SSFA was making, which was really, unfortunately, very sad and very limiting. They argued that admissions is a zero-sum game, which means that if you get a point or a tip because of your racialized experience or your heritage or your ancestry and your lived experiences, much like Taylor had just discussed, that means inherently that because you're not giving a tip to white applicants, you are discriminating against them, right? But if that point, which is not true, because again, we know that race is not a determinative factor in admissions, but according to their worldview, if this admissions is a zero-sum game, then let's go back to Justice Ketanji Brown Jackson's points, like what are we valuing? Right? If you are talking about a zero-sum game, then who are you rewarding in the zero-sum game and why? Right? So they want both things to be true here, and they cannot live in this unison that SSFA would like to really portray. And the other point that I think it was Justice Kagan who got SSFA to make very starkly was that race is never a compelling interest in admissions. That it can never be and even if minority or communities of color's applications fell drastically, that's okay, because it cannot be a compelling interest in a university's admissions or in their goal to achieve the educational benefits that flow from diversity. So that really was a lot of the meat, and of course there are many other points. And then I want to just turn quickly to Harvard. And again, some of the argument, both at Harvard and UNC, really focused about how can one take into consideration of race, and what amount of that consideration in the grand scheme of things is okay. And there was some very interesting back and forth with Justice Gorsuch, who said that if we allow consideration of race, and if we agree that race and diversity are educational benefits that are worthy of compelling interest, that's a legal standard, does that mean that other things, these other points, right? UNC at 40 plus points, Harvard has a whole bunch of other things that they want to focus on in their student body to achieve overall diversity, not just racial diversity. If we eliminated some of those things, like, you know, a preference for UNC hypothetically as a preference for students who are coming from rural areas of North Carolina, or if Harvard wanted students to matriculate from a humanities major, if eliminating these so-called preferences for these types of things, including legacies or athletics or whatever the situation might be, if that achieved the racial benefits of diversity that Harvard and UNC or other institutions are seeking, is that required first? And that's an open question. And I think that that is something that the justices were very actively trying to grapple with, to say like, okay, well, what do universities have to do to show that their consideration of race is very narrowly tailored, so it isn't portrayed to be, even though it never is, the racial balancing, which is unlawful, that it's not a set aside and it's not a quota, all the things that we've already discussed that affirmative action is not. And so, yeah, so I'll stop there and let my other colleagues chime in about some of the other things that came up at oral arguments.
And I'm just seeing in the chat that Deanie would like us to pivot to taking questions. We'd absolutely be happy to do that. And hopefully, as we answer anyone else, Taylor and Rita, you can also add your experience.
Yeah, for sure. Thank you so much, everyone. If we can give a round of applause. Thank you so much for speaking. So we're gonna move into the Q&A section. I don't know if like y'all can like project onto here, but if you guys like ask a question, I can just repeat it in. So does anybody have any questions? Yes, right there.
I have a question. In all of these arguments, is there any distinction that's being made between ethnicity and race, or is it kind of all just being one?
Could you all hear that? Sorry, what's your name again? Aisha asked, actually, let me like switch the camera so it's like that. So Aisha asked, in all these arguments, is there any kind of distinction being made between race and ethnicity?
No, not really. I mean, like a little, well, yes and no. I think like the answer to that is tricky. And so today, one of the questions that I believe Justice Thomas asked, a lot of the conservative justice asks this, they were like, I'm confused. What does race mean? Like what is race? And then they would start to get into these really nitty gritty type of arguments, some of which even undermine tribal sovereignty, and in terms of how Indigenous people identify and how it is that we identify our own people in our communities. And it was a really, really hard thing for folks to do. And I think one of the justices that did a really good job with sort of pulling and teasing some of that out, I think, was Justice Ketanji Brown Jackson. I think Justice Sotomayor also did some of that. I think they were pulling the questions out and explaining that. And when in one of SFFA's arguments, one of SFFA's arguments was that, well, you can consider certain kinds of conversations about your cultures and things like that, but you just can't talk about your race. And then Justice Sotomayor was like, how do you talk about that, but you don't talk about your race, when your race basically gives away your ethnicity, and sometimes your ethnicity gives away your race? And what happens if you have a name that gives away where you're from, or your name is directly connected to your people? How do you distinguish any of that? And that didn't really seem to get answered. It seemed like a lot of the folks were sort of coming back around to, well, we know that race is a sort of made up thing, but race also still has meaningful differences and meaningful impacts in how it is we understand our society. And so even though race is a social construct, it is something very, very real that everybody in this room and everybody on this conversation has to experience in some form or another.
Yeah, and I just wanted to add really quickly, like in terms of listening to the whole oral argument, it was really frustrating hearing like certain justices portray Asian Americans as a monolith. They were like, oh, these like hardworking Asian Americans, and they're like, they had like these great test scores and stuff. And it was really frustrating on my end because, like, you know, in terms of the difference between race and ethnicity, like there are a lot of different kinds of Asian American experiences, like different kinds, like different people have different test scores and things like that. And I remember very distinctly, like at the end, SFFA had this like final comment where they were like, oh, like Asians are like this, Asians are like that, but they're not Asian. They're well, let's say what they really are. They're American. And I had a very visceral reaction to that. Like, I remember like I started breathing really heavily and like Taylor like was sitting in front of me and was like, are you okay? But it was just like, you know, I studied ER&M at Yale. Like I know where the term Asian American comes from. Like it comes from student activism. And like that just like was a very like visceral reminder of how like this team that's purporting to represent Asian Americans like does not represent me.
There's a question that was asked in the chat that I want to highlight. I think it may have been answered, but say a student were to write about their experience with race in their college essays. I'm assuming in a world where affirmative action isn't a thing, would that mean that admissions officers would have to essentially throw out that essay because it's not something they'd be allowed to consider?
So I think that's a it depends answer. There was something like, if you talk about overcoming discrimination and racial barriers, then you can consider it for the characteristic of grit, was SSFA's answer, but you cannot consider it for your racial experience. And, obviously, Justices Sotomayor, Kagan, and Justice Ketanji Brown Jackson were all over that, going like, how is this workable, right? Like, how are you trying to parse out what your identity and your lived experiences are outside of race, and how is it a demonstration of characteristic A and not of B, and how you're supposed to parse all of that out? Like, how is that really possible? And to me, over and over again, I keep coming back to this at the end of the UNC argument, what Justice Ketanji Brown Jackson was doing, like, well, what are we trying to value, right? Like, if we're valuing grit, is grit only valuable to the extent that you've based on your race experience, or like, is your racial and lived experiences based and your cultural heritage and the richness of that not valued? Right? Like, if I wanted to talk about how I'm so lucky that I have a large extended Indian American family, like, is that not something that we want to value, and how that has shaped me into a caring person who also wants to make everybody a part of my extended family? Like, does that not matter? Are we not going to put value to that anymore because it is based on my race?
Just to piggyback on that, I know I talked about this a little bit, and this actually sort of played out with one of our clients in the Harvard case. One of our clients, Itzel, she shared her experience in her application about who she was. She talked about being Chicano. She talked about being of indigenous like heritage. She talked about all of that. But when you looked at her admissions application and you removed it of race, it looked like an entirely blacked out, Word document. And it looked like, you're reading some FBI documents, honestly. And when you look through it, you might see like half of the sentence here, and then maybe a couple paragraphs down, another couple of sentences, and maybe like one word over here. And it looks like a whole piecemeal project. And it doesn't make sense like that, because if you've ever tried to read a redacted document or anything like that, you're trying to figure out, you're trying to guess, you're trying to figure out context clues, but you don't get the full context of the person without being able to see it colored, by their lived experiences with race. And so, I mean, I don't know how one would be able to talk about those kinds of things without directly implicating that. Like, how do you talk about your experiences as a person, or how do you talk about your classroom experiences if you're like me and you've been one of 4 people in half of all of your classes most of your life? Like, that shapes all of your experiences. I mean, it might not be the main motivating thing. There might be other things that are salient. It might be that language is more salient. It might be that your geography is more salient. It might be that your gender identity is more salient. But in all of those different things, how do you tell who you are in the most fundamental way to a person that has never met you, without being able to unpack some of what makes you who you are, like your cultures, like your communities, like the people that made you you?
Any other questions?
I know we're over time, but I was quickly wondering if you could potentially elaborate more on the 14th Amendment's equal protection clause and how FSA was particularly covered.
So the question was could you elaborate more on the 14th Amendment's equal protection clause and how SFFA is kind of leveraging that in their oral arguments?
So I think as we touched a little bit about this was an originalist argument. And I think I forget whether it was Taylor or but who mentioned that, they were kind of saying race can never be considered. But we talked about the originalist argument that why the 14th, 13th, 14th, and 15th Amendments were enacted, and how Title VI flows. The conservatives tried to use Justice Stevens's opinion I believe Bakke, but that Title VI talks about no discrimination on the basis of race. And so, how does that comport with the 14th Amendment? And it was just, it was laughable. Why were these amendments enacted? What was the goal? And, to use the word permeate, which was used very disgustingly early in the oral argument by Justice Roberts, that that race permeates all aspects of university life these days, including affinity groups. It was really just heartbreaking to hear that, and that's a negative. But to go back to the question here is these amendments, race permeated them, and all of us are beneficiaries of these amendments that we fought an entire Civil War for. So to say that that there's no there is a little doesn't pass the laugh test for me, anyways.
And one thing I'll add that I think is really interesting is there was actually, I believe it was questioning by one of the three more liberal justices about the original. Some of the questioning about the original intent of the 14th Amendment was prompted by some of the more liberal justices. And I think that's interesting because originalism was sort of a project of a more conservative justice, and as plays a role in the court sort of strike in the Dobbs decision overturning Roe, talking about abortion not being within the meaning of the 14th Amendment. But as Taylor mentioned earlier in the presentation, many legal scholars and attorneys have been pointing out for a very long time that the 14th Amendment was race conscious, right? That there is that the original interpretation does allow for the consideration of race. And so it was sort of an interesting strategy, I thought, to harp on that point here and make it very clear that using the sort of the legal interpretation theory of the conservative movement, which is to look at original intent, that's actually an argument here in favor of consideration of race.
All right, so we are a little bit over time, but thank you so much, everyone who spoke. And one more round of applause. So a recording of this will be made available, I believe, on the ACC YouTube channel. But thank you everyone for coming and showing up. Thank you.
Thank you so much.
See
We
y'all.
look forward to talking to you guys again soon.
And I'm gonna put my email in the chat if anyone